I can assure you that what you will observe is a vast wasteland.
It is to try and channel it for
You will see a procession of people
deny what they think is false, argue what they think is false. You have to have free and uncorrupted communication.
I am very impressed that you chose me, this, rather than Star Wars across the street. Now, I know some of you may have seen it or maybe even don't want to, but nonetheless, I'm going to go home and tell my family they were here. Oh, yeah. I thought I would talk to you a little bit on a broader basis, maybe, than my book does about some of the areas which interest me and to some extent concern me most about what's going on in the world today. Some of those things are indeed the very things that took me into this area of law in the first place. I started practicing law in what we'll call the First Amendment area in the late 1960s. And at that time, there was just beginning, under President Nixon, a serious effort to cause journalists to reveal the identities of their confidential sources. Starting with a lot of subpoenas which issued after the Chicago Convention in 1968, and a number of other events, some of which had nothing to do with national politics or affairs at all, but some of which did, which led to a torrent of subpoenas descending on the press throughout the very late 60s and early 70s. And the case which finally went to the Supreme Court involved a journalist from Louisville, Kentucky, named Paul Brandsburg, who had come upon information showing that hashish was being made and sold in Louisville very easily and in great amounts. He made a deal with a person who was involved in doing it, and the deal was they'd let him see how they made it, where they made it, what they did, how they sold it, in return for a promise of confidentiality by Brandsburg about who he had seen involved. He published his article in the Louisville paper, and he was subpoenaed the next day to appear in front of a grand jury. The prosecutor, incidentally, took no steps other than subpoenaing the journalist. I mean, he didn't take any of the leads the journalist had provided in the article, just subpoenaed Brandsburg. And that was the case. There were two others involving Black Panther meetings which journalists had attended. It was the Brandsburg case, which was the lead case in the Supreme Court. And as a pretty young lawyer, then I was working on a friend of the court brief for a number of media entities to submit to the court, urging the court to rule in favor of the press in that case, and to say that there was a privilege, something like what lawyers have to clients, not to reveal what clients tell them, something like what priests have and other members of the clergy, not to reveal what they're told in confidence, something like what husbands and wives have with each other, where one's not allowed to testify against the other without the consent of the other, all for the same basic purpose of allowing the communicative process between someone and someone else that society considers important to allow to occur without being chilled or limited by being exposed to public view. And all based on the same notion that if the information had to be revealed, people wouldn't confide in the same ways. I remember the argument in the Brandsburg case. It was one of the first I ever saw in the Supreme Court. A young lawyer from Louisville got up representing the judge in the case who had sentenced Brandsburg to jail. He could not have been 30 years old. And he walked up with enormous self-confidence and was confronted, in the Supreme Court. It's mostly questions and answers. No lecture like this. It's Q&As, hypothetical Q&As. If this is the law, then what about that case? If this happens, what about that case? Well, his first question came from Justice William Douglas, who very rarely asked questions. And Justice Douglas said, let me ask you a question. He said, do you think in a case of this magnitude, it is appropriate for you to have given this court a brief of only 4 pages, which did not cite a single case from this court? And the young lawyer looked up. I can see it now. And he said, you have to realize I'm a very busy man. And everyone in court, except Justice Douglas, sort of collapsed with laughter. He said, I've got 200 cases that I'm working on at the same time. I did the best I could. I thought the Kentucky case I was citing was the right case. Well, through the years, I've had an image of him going back to Louisville because he won 5-4. He won the case. And I've always thought he must be walking the streets for his whole career, thinking to himself, I beat all these people, these fancy New York lawyers and Washington lawyers and justices laughing at me and everything else, and I won. Since that decision, which was 1972, we have, and through today, we have been fighting about whether he really won and how much he won if he did. And the reason for that is that, well, I spoke accurately in telling you that he won by a 5-4 vote. The fifth vote, Justice Lewis Powell also wrote a separate concurring opinion. He joined the opinion of the 5, basically saying there was no privilege of the press under the First Amendment. But he wrote a separate opinion. And it basically said to the press, oh, don't worry so much, it'll be all right. He said, the courts will still be there to rule on a case-by-case basis, and the courts will still be there to balance, on the one hand, the First Amendment, and on the other, how much a prosecutor really needs this information. Well, if that's the law, then you might think maybe there is some sort of privilege. And for all the years between 1972 and now, lawyers like me have been arguing in the courts about whether there is or is not any privilege, and if there is some privilege, what it is, how broad it is, how sweeping it is, whether it applies in criminal cases, for example, as well as civil cases, whether it applies in grand jury situations, which is the very one that Brandsburg had, and the very one that I have now, representing Judith Miller of the New York Times. Judith Miller is a reporter who's been with the Times for a number of years, who was one of a number of reporters who gathered information about what's become known as the Valerie Plame matter or case. Ms. Plame was a secret CIA operative. She's still in the CIA, and I'm sure you've read about it. She was identified by Robert Novak in a column that Mr. Novak wrote and published in the Chicago Sun-Times as a CIA operative in the following context. President Bush in 2003, in a State of the Union message, which was basically focused on why it was likely and necessary to go to war in Iraq, One of the observations that the president made was that English intelligence had told us that Saddam Hussein had sought to purchase uranium in the African country of Niger. And the president said there would be no reason for Iraq to purchase uranium except to build atomic weapons. The New York Times the following week published an article by a former U.S. ambassador named Joseph Wilson. And Mr. Wilson, I'm going to do the same thing, as a matter of fact. I realize my phone's on too. Ambassador Wilson wrote an article saying, how could the president say that? I was sent, he said, to Niger. I was sent there by the CIA to check out whether it was true or not that Saddam Hussein had sought to purchase uranium, and I made a report to the CIA saying that I couldn't find any support for that at all. And yet the president, in his State of the Union message, citing British intelligence, said just the opposite of what I reported. And then he attributed political motives and the like to the president and the vice president. The White House then was asked, and the government, the administration was asked, well, what about these charges by Mr. Wilson? And first the White House and everyone had to find out who Mr. Wilson was. Not everything moves so quickly in Washington. And they learned he was the former ambassador, etc. And then someone or some people provided in confidence to various journalists basically the following story. Don't take this guy so seriously. Just don't credit him too much. He says he went to Niger for the CIA. Well, you know who sent him? It was his wife. It was his wife. His wife's in the CIA. She was involved in sending him. She, in fact, the information was she was the one who suggested him. And so the theme was not to take Wilson at face value in terms of what he was saying. Mr. Novak published an article saying just that, criticizing Wilson, basically mocking Wilson, and saying, in part, at least accurately, that it's not as if the head of the CIA sent him, he's not the most important guy in the world, etc. And his wife Novak described by name, as a, quote, CIA operative, unquote. Other journalists had also received similar information. And Matt Cooper, the White House correspondent of Time magazine, published an article a few days after Novak basically saying, it's too bad, isn't it, that the White House is trashing this guy, Wilson. We also received information from administration sources telling us that Valerie Plame was a CIA agent. He didn't quite say, but the obvious import was we didn't publish it because we don't always publish CIA agents' names. But now that Novak's published it, he was critical of the administration. Judith Miller gathered information, thinking to do an article about Wilson, and wound up not writing an article at all. The Times did not publish an article about this. Well, what happened next was an outcry, led primarily from within the CIA, but also many in the press, saying it's an outrage for Novak, for Novak to have published, but for someone to have leaked the identity of a serving and presumably covert CIA agent. And by that time, people started to realize something else, and that was, this may be a crime. In 1980, the U.S. passed a law providing that people in the executive branch may not provide the names of CIA agents who are covert and secret agents if they've been if they are secret, if the person knows that they're secret, if the agent has been abroad within the last 5 years. I mean, there are a number of requirements, but the core principle of the law is that executive branch officials should not leak the name of secret CIA agents. And so an investigation began. A grand jury was impaneled, a special prosecutor was appointed, and the special prosecutor has gone so far as to question the president himself, to question the vice president, to call the Secretary of State Powell then in front of the grand jury. And he then, or at some point at least, turned to journalists. And where I am now, in terms of what I'm doing, is spending a great deal of my time representing Judith Miller, and I had represented Matt Cooper also, to try to help them in a very difficult predicament in which they find themselves. And the predicament is they've been ordered to reveal their sources, and they won't do it. They won't do it because they promised not to do it. They won't do it because they believe they won't be able to basically do their jobs if they do it, and they won't do it because as a matter of principle, they think they shouldn't do it. The notion that journalists believe that goes back a long way. It predates the revolution itself. Not 5 miles from where I live in New York City is the place where John Peter Zenger, the publisher before the revolution, published articles criticizing the British governor of New York in 1734. He was jailed for that for 9 months and then tried and as it happens, acquitted in a very famous case. While he was in jail, they tried to get him, to pressure him to reveal his sources, and he wouldn't do it, nor would Benjamin Franklin reveal his sources when he was working on his brother's Philadelphia newspaper. And through American history, journalists have taken the position that they ought not to be asked to reveal their sources and that they will not reveal their sources. Yet the only case the Supreme Court's ever decided is the one I talked to you about earlier, that Brandsburg case from 1972. Now we have filed with the Supreme Court a request that the court hear the case, a petition for a writ of certiorari, in which we ask the court to hear the case in the fall and to basically answer the question. Some people on my side are afraid of what the answer might be, but to basically answer the question whether there is legal protection here or not. And if there is, it is presumably qualified protection. That is to say, some sort of balance has to be struck between the needs of society for information and the needs of society for a free press in which journalists can promise confidentiality. And therefore, the question would then be, all right, if there is some protection, what happens next? That's where we are in the case. A lot of people ask the question, and I've been asked here already, what about Novak? I mean, why is the person who brought this about not at risk when Judith Miller, who didn't even write a story, is, and Matt Cooper, who criticized the leakers for providing information? Why are they in trouble and Novak not? We don't know the answer because it's all secret and in front of the grand jury. The only sense I can make of it is this: there are only two real possibilities. One is Mr. Novak's testified and revealed his sources. Remember, this is not a matter where Judy Miller's being put in jail for what she didn't print. It's because she's on the lip of jail because she won't answer questions about information that she's gathered. And so with Novak, if he's prepared to reveal his sources, if he's done it already, presumably he's not in legal trouble. I mean, he may be in or should be, in my view, in journalistic or ethical trouble if he did that. The other possibility is that he's taken the Fifth Amendment, which provides, of course, that you can't compel someone to incriminate himself. And he could be taking the position that he is at some level of jeopardy, which is conceivable. The striking thing there, though, is that if he were really at jeopardy, the potential jeopardy, and the government really wanted this information, you would think that they would have tried to immunize him, to force him to testify by saying, as prosecutors can, look, you don't have to worry about being indicted. We're not going to charge you with anything. Just tell us what happened. And if they're willing to do that, then he wouldn't have any Fifth Amendment right left. In any event, where we are now is that the court will tell us at the end of June whether or not they're going to hear the case, probably on June 27th. If they do agree to hear the case, we'll have an argument in probably October or November. If they don't agree to hear the case, then there's a high likelihood that Judy Miller and Matt Cooper will be sentenced to incarceration of some sort for up to 18 months and might have to serve a very prolonged sentence. This all comes up at a time in our history, our country's history, in which the press itself is in a lot of trouble with the American people. And that trouble with the American people has impact on judges. Not because judges slavishly follow, but because they tend to share the same reactions as other people do. There's polling data. A 2003 study says that 66% of the American people believe the media is biased. 32% believe that the media is immoral. And a 2005 study says 45% of the public believe little or nothing of what they read in a newspaper. Now, apart from the fact that it makes my clients so miserable to read things like that, I must tell you that the last line, which I'm quoting, is very close to what Thomas Jefferson once said while he was president. Jefferson, of course, was perhaps our greatest defender of the press while he was out of office. And he is the most quotable, in the best sense, quotable, poetic, brilliant president in terms of setting forth the nature of liberty and the need to protect a free press. But while he was president, he did observe once, "Nothing can now be believed which is seen in a newspaper," which is not that different from what 45% of the public told pollsters this year. The problem, I think, is this. We meet today at a time in which there have been a lot of media scandals. We meet at a time in which there's been a concerted effort made with great success to delegitimize the press in America. An awful lot of effort has come from the far right to say that what we used to call the establishment press is basically biased and on the left, and that the New York Times, the Los Angeles Times, CBS News, Time Magazine are all the functional equivalent on the left of Rush Limbaugh on the right. Now, I don't think any of that's true, but to the extent people believe it, it's very bad for the credibility of the press, and anything that is really bad for the credibility of the press has unhappy legal consequences as well. Because in a sense, one of the issues that the court deals with, that the Supreme Court deals with, when it deals with confidential sources of journalists, is a question of trust. If the court really believes that journalists routinely just fabricate stuff, make up sources that don't exist, or grossly misrepresent what the sources say, they're a lot less likely to take the extra step of saying, you know, we will trust them. We will take a chance and say it is so important that we keep open the lines of communication between sources and the press, and therefore the press and the public, that we'll run some risks of bad journalists, immoral journalists, or just poor journalists. And the more people think that that's not the case, the more problems we have, which brings me to something I wanted to say about the Newsweek situation that I'm sure many of you have read about in the last week. Newsweek, as you know, acknowledged that a brief item it published in its Periscope section, which said that a forthcoming report of the Army would be saying that at Guantanamo there was at least one case of significant abuse of the Quran by American interrogators or soldiers, and that including flushing it down a toilet. There were riots in Afghanistan and demonstrations elsewhere. 15 people have died as a result of the riots. Newsweek ran an article saying that their source, their key source, the only source for this information as such, was now saying he wasn't sure about it, and therefore, and after a good deal of pressure from the administration and from others, they retracted the story. The broader way, I think, to view this is that one of the reasons they thought the story was credible is that there had been repeated charges to the same effect by a variety of prisoners in Guantanamo who have reason to lie about it, but nonetheless, on a number of different occasions and in a number of different places, had said that they had themselves seen something like this happening. What I find most troubling about this is the reaction of the administration, which has really been to pound Newsweek and to say in so many words that they are responsible for the deaths of the people and for the harm to the United States from all the demonstrations. But the only one connected with the White House who has said something different is Mrs. Bush, who said very clearly that in her view it was wrong to blame Newsweek for all this harm. More important in terms of on-the-ground knowledge, the top commander of the U.S. in Afghanistan was quoted by General Myers last week as saying that the riots were not at all tied to the articles in the magazine. Yet nonetheless, this pounding does go on, and it gets to the point now where it sounds very much as if spokespeople from the Defense Department and from the White House, not the president himself, but the White House press secretary and the press secretary from the Defense Department, in a coordinated effort, are coming very close to saying that the American press in the future should make its determination as to what to say based on the potential behavior or misbehavior of religious fanatics in Afghanistan, or elsewhere in the world, as well as saying that the administration can properly play a role in pressuring the press to write more favorable things about American behavior abroad. I find it very troubling, and troubling from a First Amendment perspective, not a sort of lawsuit perspective. No one's going to call me up and send me in, team, on this. But the idea of the U.S. government coming out so strongly and fervently, and in my view, irresponsibly, in pressuring the press about how to cover news, even in a context in which we should at least assume that Newsweek erred in its article, is very disturbing. In my book, I have tried to deal with a number of cases that have come up through the years, many of which I think help to tell a different story about the threats to freedom of the press in the last 30, 35 years, and the way the courts have treated it. I start with the Pentagon Papers case, 1971, which was a classic press-government sort of clash, which arose during the war in Vietnam, in which the New York Times was given copies of certain top-secret documents which dealt with how the U.S. got involved in the war in Vietnam. Secretary of Defense McNamara had decided well into the war that he wanted a report, an analysis of how the U.S. became involved. You might think it's the sort of thing the Secretary of Defense would ask for before we get in the war, but in any event, he asked for it. It was prepared, it was voluminous, and it leaked, all except certain volumes dealing with ongoing negotiations to end the war. And the government went to court to stop the Times from publishing. It was as I say, a classic, not just in terms of importance, but the very notion of the government going to court and saying, you shouldn't print that, you may not print that, was made it a very important case. The Times won. I think the best way to look back on it is to ask the question, what would have happened if the Times had lost? Because I really believe that we would live in a different sort of country if that were so. It would still be a free country in most respects. Information of this sort would have been criminal in England and in Canada and other free countries. There would have been a restraint against publishing it in both those countries, as well as just about every country in Europe. This is our special law under the First Amendment, which so distinguishes us from the rest of the world. I do think that one can say that because of this case, no president in let's say, since 1971, however angry he was at the press, and however much he thought the press was disserving the country as well as being unfair to him, and every president has thought that. And some of them have thought it deeply and intensely. Every one of them, or I should say it the opposite way, none of them ever gave any serious thought to suppressing the speech, getting a court order saying you can't print that. And that would not have been the case, especially since Washington leaks so much. And so much information comes to us from unauthorized sources in all these other democratic countries. And if you like, we can talk about that during the question period. In all these other, good, free countries, there would have been court orders stopping publication of certain information. Here, in good part, because of the Pentagon Papers, it is all but off the table. It is simply not a weapon that the government has. Presidents don't think about it. Their advisors just tell them, forget it. That's something you just can't do. I should add as I go along that one of the reasons that so much leaks in Washington, and not just under this administration, is that so much is secret in Washington. And so much is secret that never had to be secret in the first place. And the more that that is true, the more that will leak out. In any event, I then go on and describe, I'm not going to take your time to go through this whole wonderful book, but I talk about 3 libel cases which I think illustrate what's happened and the changes in libel law. Again, the changes from what is true everywhere else in the democratic world that we have, where basically what we have said is that when the press publishes a story about a public person, someone in the government or very powerful outside the government, or who's thrust himself or herself into public debate, even if it's arguably not true, they can't be liable. They can't have to pay money in a libel case unless they acted with bad faith. So long as they tried to get the story right and didn't publish it, knowing that it was untrue or with serious doubts as to truth or falsity, the press is free to go ahead. That, too, to come back to what I said earlier, is an earlier example in our history of the Supreme Court basically saying to the press a sort of, either we trust you or we think there are less risks to the country in letting you have your say than in allowing enormous judgments, money judgments, to be entered against you when you're writing about powerful people and you're writing in good faith. I then wind up the book talking about 2 quite recent cases, one in which I represented the Brooklyn Museum in New York against then Mayor Rudolph Giuliani, in a case in which Mr. Giuliani sought basically to close the museum down and to expel it from its premises because it refused to take a picture off the wall that he found offensive and he thought was blasphemous. He believed was anti-Catholic, and he thought that a museum which received any subsidy from the city, and the museum received about 22% of its money from New York City, should not be permitted to have such a picture on the wall, whatever its artistic merit. That was a very big case in the days before Mayor Giuliani became what the New York Times has referred to as a secular saint. So in those days, we were we had at it with him. And finally, I wound up in a case in which I found myself with unusual allies for me, just given my own political views. And that was the campaign finance case, in which I represented Senator Mitch McConnell of Kentucky, a conservative Republican, and the National Association of Broadcasters in challenging the campaign, certain portions at least, of the Campaign Finance Act, the McCain-Feingold law. And the part that troubled me was the part that basically says that no union or corporation can publish any advertisement which mentions the name of a candidate for president or running for the Senate or the House within 60 days of the election in which the person's running in the state, or in the case of the president, in all the states, where the person is running. The effect of it in the last campaign, we lost the case 5-4. The effect of it in the last campaign can be shown by 2 examples, which I was personally involved in. One, I got a call from the distributor of Michael Moore's documentary, Fahrenheit 9/11, and they wanted to know, were there any limits on what they could do by way of getting this film out because of the McCain-Feingold law. And the answer was that they couldn't advertise it on television with the ads that they were running, ads showing President Bush, and it turns out in an unflattering way, but flattering or not, they were not allowed to mention his name or show his picture in any ad within 60 days of the 2004 election, or within 30 days of the Republican convention, or within 30 days in any state in which there was a Republican primary. And similarly, my own publisher, Viking, called with a legal question of me. They published a book about Senator Kerry in the last campaign. His name was on the book and his picture was on the book. And they wanted to know what limits there were on them, if any, because of the McCain-Feingold law. And I had to tell them that the effect of the law was that they couldn't advertise that book within 60 days of the national election, within 30 days of the Democratic convention, and in any state that had a primary scheduled within 30 days of the primary. My view was and is that that was a sort of First Amendment overkill in the course of a cause that I understood very well and had some sympathy for, of trying to get money out of politics or trying to limit the degree to which large moneyed interests, such as corporations and unions, can distort the political process. But the effect, in my view, of the law was to cut too deeply into free speech rights, and I thought that should not be allowed. As I said, that was a 5-4 opinion. You know, when you look back on cases in the Supreme Court, it's always hard not to think about what might have been. I started my talk with you talking about how in this 1972 case we lost, or my side lost, this Brandsburg case by a 5-4 vote. The year before, Justice Hugo Black was still on the court, and we would have won by a 5-4 vote. That's one of the reasons appointments of Supreme Court justices are so important. I want to close before doing questions by just assuring you of something. I used to have a cartoon on my wall at my office of an old New Yorker cartoon which showed the members of the Supreme Court all sort of huddled around, and one turns to another and says, "Do you ever have a day when everything seems unconstitutional?" I just want to assure you, I'm really not like that. The book is filled with things that I think, and the courts generally thought, were unconstitutional. But there are some things that are constitutional. There are some laws the government is allowed to pass. Even in the speech area, we have to draw some hard lines about some difficult issues about what is speech and what is not. Is it, in the late 60s, there was a case in the Supreme Court in which people slept in Lafayette Park across the street from the White House as a protest. Question, was that speech of the sort that's protected by the First Amendment or not? Then, of course, you have the application of the First Amendment to all the new forms of technology. To what extent will the Internet, obviously the First Amendment will apply and applies to the Internet, but will there be any differences at all because of the different form of technology? I served as chairman of an interesting commission in New York last year, in which we were dealing with what turned out to be, to me, a surprisingly hard issue. The issue was, should there be any difference at all in the treatment by the courts of information revealed in court in a public way because of the Internet? And the way that comes up is this. The general rule is, if something is public, It's really public. That is to say, if something is said in open court, if a document is available in the clerk's office, anybody can go get it. The question was, is it different when what you're talking about is not going to get a document in a courthouse, but the judicial system itself saying, from now on, we're going to post on our website every public document we receive. It's not easy because in a lot of states, Florida, for example, a lot of material that is very confidential by its nature is still made public. Divorce records, for example, which tend to be closed in New York and in many states, are more open in some other states. Adoption materials, stuff which is really at the heart of personal relationships, often with no particular public value except once it is in a public file, it is, as a matter of course, generally available. So we spend a good deal of time talking about whether the fact that the internet is available on a 24-hour basis, 7 days a week, should lead to any different rules. And our conclusion basically was no, but that we had to take better care about what became public in the first place. So, for example, Social Security numbers, we said, should not be introduced publicly in court unless there was a very, very good reason for it. And otherwise, we said, you could use just the last 4 digits or the last 3 digits or something like that, because Social Security information can be used to help stalkers find out information about people and to help other people find out information which impairs your potential use of credit cards or the like. I cite it only as one example of the difficulty of dealing with the impact of new technology on pre-existing rights. I mean, the right that generally exists is that all of us can walk across the street to any courthouse and look at any public file and get a copy of it, and look at a transcript of a trial and make a copy of it. And any journalist can do that. And if they couldn't, a lot of news would really be lost. But whether that should be the rule in the new internet age where everything is available all the time, at least turned out to be a harder question for us and other states. In fact, every state is now in the process of considering what to do in that area. A final thought. The First Amendment is one of the most unique contributions that the American Constitution has to offer. In good part, the Bill of Rights is as well. I started out my own career with a very different view than what I came to about how to read the First Amendment. I did so when I was in college. I wrote papers about how I thought we should adopt something like the English system, in which I said if a journalist comes upon a confession, say, in a criminal case, which has not been admitted in evidence, I said they shouldn't be allowed to print it. If they print it, they should go to jail. Tough. I said if a journalist gets information about a prior criminal record, which is not introducible in evidence, the same thing ought to apply. That is the law now in England. And journalists do go to jail occasionally there when they publish such material. We've gone a different route. We've given defendants more rights than any defendants has anywhere in the world. And we give the press more rights than any press has anywhere in the world. To put it differently, the Bill of Rights gives enormous protection to the press, to all of us, to criminal defendants and the like. And that's the basic balance that we have struck. The press ought to be criticized when it makes mistakes, and it does make mistakes. But I hope that we can continue to provide the sort of uniquely American, sweepingly broad protection for the free press that only we do. Thank you very much. That there is a microphone here. Yes.
This isn't directly about the press, but about First Amendment rights in general. It seems that in America, more and more public spaces are actually privately owned when you have like these shopping malls and things like that. And just wondering, what is the legal status if, let's say, you want to distribute literature and you're in one of these private public spaces?
So far, the Supreme Court has said that a shopping mall, for example, is private for First Amendment purposes, and that the First Amendment doesn't apply there. Many states have given a lot more protection than the Supreme Court. New Jersey, for example, I know has. New York has. I don't know the California law on that. But so far, at least, that will have to be decided on a state-by-state basis. And I don't expect the current Supreme Court to move in the direction of expanding the First Amendment in this area. Yes, sir.
Yeah, I don't know if you want to take a question about the Establishment of Religion clause of the First Amendment.
Sure.
Okay. Given that not $1 has gone to a non-Christian organization under Bush's faith-based initiative program, how does that not violate the First Amendment clause against establishment of state religion?
If there were a policy of only giving money to Christian or any other religious causes, it would clearly violate it. I mean, if someone could prove that there were a policy of that sort, rather than just the happenstance of it, it would clearly violate the First Amendment. I mean, if Jewish groups, Muslim groups, other Christian groups than the sort which may be getting this money had applied and been turned down, and I just don't know what the facts are, that would be a solid and an easy First Amendment case. Yes, sir.
Mr. Abrams, thank you very much. I think it was a very wonderful talk. I'm wondering about your recent submission to the Supreme Court and the perhaps competing values on one hand, wanting to protect journalists from having to reveal their sources, but at the same time, the American public's need to know about the possible administration tactics of attempting to punish those that are speaking out against it. There are two speech rights, it seems to me, in conflict here. And so while one wants the journalists to be silent, at the same time we'd like to know who in the administration, even the president perhaps, is it the case that he has the right to punish political opponents by being silent?
Well, that is indeed a very succinct and powerful articulation of what the Special Counsel at his strongest is saying. Well, let me add another thing that a lot of people are speculating that the Special Counsel may have in mind. Certainly there's been a lot reported suggesting that maybe what they have in mind is prosecutions for obstruction of justice or perjury. From my own maybe narrow, I hope not, but maybe narrow perspective, it seems to me that we do need to strike a balance which will mean compromising one or the other interest that you correctly cite. It's very hard in this case to maintain them both, unless that is they don't really need the information at all. It would obviously be helpful for them to have it. Whether they need it is something else. And I put it that way because one of the articulations that many courts around the country have used in the post-Brandsburg, post-1972 era, is to say, well, look, there's no absolute privilege for the press here, but at least we can say, we can give them two sorts of protections, which add up to one general proposition. And the two sorts are that you shouldn't order the press to reveal the information unless it is absolutely central, it is essential to the carrying out of the mission of the government, central to the subject of guilt or innocence, for example. And, number two, you can't get it elsewhere. Now, the combination of that has often been said to be the press goes last. Don't subpoena the press until you've done everything else, and you can then justify to the courts that it is still necessary, really necessary, to go after the journalists. Now, the special counsel, if he were here, would say, I did that. And a number of judges who have already looked at the documents here have said, even if there is a privilege, you guys would lose. We would still make you reveal the sources in question. One of the problems in this case is that they won't even show the information to me. So even as Judy Miller's lawyer, I have not been permitted to see the submissions made by the government, by the special counsel, to the court, because they have been submitted in secret. And the courts so far have said, because the material submitted in secret is grand jury material, and we like to keep that, and it's important to keep that secret, we won't let even you see it. Put aside my client. Even I, with all the sanctions the court can impose on me, they won't let see it. Now, we have argued in our papers to the Supreme Court and the lower courts that violates the due process rights, the fairness rights to our client. That we have a client that's on the lip of jail, and you won't tell her, or you won't tell even her lawyer, what the basis is for saying that her privilege, if she has one, has been overcome. That said, I have to interject with a story. I found myself saying, we say, they say. When my daughter was about 12, she's now in her 30s, and I became a grandfather for the second time last week. When she was 12, I found that she was about the perfect age for me to use her as a make-believe court. She had, I thought, just about the same tolerance for pain as most judges do. And so I'd go into her room and she would say, all right, what do you say? What is the case about? And she would have, room for 3 or 4 sentences, and then she'd say, all right, what do you say? And I would talk about it, and then she would say, what do they say? And then she'd sort of rule. She's now a lawyer, of course. Well, once I phrased it in the same words I just heard myself saying, once I phrased it in terms of saying, we say the First Amendment means this, and they say the First Amendment means that. And she looked at me, she said, doesn't anybody read it?